For in all the states of created beings capable of law, when there is no law, there is no freedom, says John Locke. A very good morning to one and all. I, Krusha Bhatt,
and I, Deepthi Babel,
welcome you all to the National Conference on Law and Justice 2015, organized by Oro University.
As per the tradition of our university, we begin all our programs with 2 minutes of silence. I request you all to remain silent and concentrate with Guru Vandana.
Now, we proceed with the inaugural ceremony by lighting the lamp. I request all the dignitaries to come forward for lighting the lamp. Thank you all.
It gives me immense pleasure to introduce Dr. Rohit Singh to you. Dr. Singh is the Associate Dean at Oro University and Head School of Management. May I now request Dr. Singh to kindly deliver the welcome address.
Thank you all. Honorable Justice Tripathi, Honorable Professor Vikram Desai, Convener of the Conference, Professor Shilpi Sharma, Session Coordinator, Professor Ankita Khanna, my honorable guests, Ashok ji, my other faculty members from the different institutes, my faculty members of the university who are helping us to organize these kinds of events, and my adorable students who are always there with me to take an extra step in the process of learning and teaching. I extend my warm welcome to you all on behalf of my Provost, Dr. Vivek Bhandari, Honorable Chancellor, Shri H.P. Rama, CEO, Mr. Mathur, and CFO, Mr. Nayan Banker. And I extend a warm welcome with a pride that this is the third National Conference of Law and Justice which we have organized, and this is just because the kind of feedback, reviews, active participations from the delegates, faculty members from the different institutes, and above all, students from the university and across the colleges from India. I recognize few faces who are back with us into this conference. I hope this gives us much more, energy to improve ourselves into this process of teaching and learning. Technically, I am not from the field of law, but whenever law is being talked about, we talk about rights, equality, justice, timely delivery, and above all, it should not be as a deterrent, but rather it should be beneficial for all. I give you 2-3 examples where we face peculiarity in terms of how law and justice is moving ahead in the times of global era. It has been discussed in the past. Is law delivering justice on time? Is the procedures which are followed is too lengthy and tedious? Do the people involved in that process of litigation and delivery of justice, they get drained out with that detailed and lengthy processes? All those issues we are also facing in our daily life when we are trying to manage the organization's business or any activity. The second question which we face is justice being delivered? When we see the judgments and we try to see it into detail, intricacies, eyes for detail into it, what happened and what not, we come to know that one party feels satisfied with the judgment, second party feels dissatisfied, or others say they still feel agreed with the judgment. Question is, judgments are delivered on the basis of facts, figures, and the details of the case, based on the wisdoms and knowledge of the people who are involved into it. Sometimes we feel it is not good for me, but in totality it may be beneficial for rest or for the society as such. Recently I was asked a question which was technically legal in nature, This law and justice, law says institution should be non-profit. So somebody asked me, press reporter asked me, when institutions are not for profit, how come fees are being decided at such level? Question number 2. When you design questions and you prepare results, few people are being caught during the examination using unfair means. You rusticate them from the semester. Are you delivering justice to them? Third question. When you say you are not for profit, at the end of the day you want to make your business sustainable. Please define me what is the definition of not for profit as per law. Now, if I see this in total picture, sometimes I am not able to give the right answer to the person who is putting a question in front of me. But if you ask me, as a teacher, for me, each of the students is equal in my eyes. That is equality for me. I am conducting examinations as per the procedure, rules and procedure which have been laid. May be fair to some, may be stringent for some other. But am I delivering it in the right way in which it should be done as per the existing rules and laws? Question needs to be answered for all those things in which people face an intricate challenge in getting a real understanding for those. We were having a discussion, I was talking to Ashok ji also, that in implementation of CCTV, and people cross the traffic signals, they run away. Now they are sending in memo. The person who gets a memo says, while I was crossing the traffic signal, there were two other also people who were driving a car. They didn't get a memo. Is it justifiable for RTO office to send memo only to me. I don't have answer. I am not from law. But actually, system is doing its job. To whom they have caught in the camera, they are sending a memo to them. Fine, we will improve that system and try to bring in those also into the process. But it does not mean that law is not equal for all. So these are the questions which pertinent question we need to ask. I was going through the proceeding. I congratulate all of you who has contributed papers into it. I was going through it, what you call misuse of patents and logo, child abuse, family law, and all those issues have been covered into the sessions. I am looking forward to discuss, try to sit and understand what are the various provisions contained into it. I hope you will all actively participate into it and you will come out with fruitful suggestions. May not be for policy implication, but yes, maybe for further discussion so that we can have much more debates, much more conferences like this. And I wish you all the best in the next 2 days and hope that in case if you have any suggestions for us to make this conference more fruitful, please help us to know. We will try to improve it. I once again welcome all the guests on the dais. Thank you very much, sir, for coming. Thank you.
It is my privilege to introduce Professor Shilpi Sharma to you. Professor Sharma is the head of law school and also the conference chair. May I now invite Professor Shilpi Sharma to present before us the details of the conference.
A very good morning to you all. On behalf of Oraganized University and the School of Law, I welcome you all to this conference. Some among you had been a part of our earlier conferences and some are new faces, and I hope after this conference, those who are coming here for the first time will build a long-term relationship for other conferences and our university. We have planned to have a conference on law and justice. It is the third time that we are having this conference that is having name Law and Justice. So we decided to call it Conference on Law and Justice because law means a set of procedures, rules and regulations that we have to follow in our day-to-day working. And justice is the correct implementation and correctly following those rules and regulations or procedures. Now, there have been many more areas coming up in the field of law which are not touched earlier or which are very new to us and the others who are not a part of legal fraternity. Like when I was a student, I never studied IPR laws. Even cyber laws were not known to us. Many more areas, many more concerns are coming up these days. So my thought was to include all those areas and all those concerns with this in this conference and have a deliberation on all those areas which are not touched earlier. So we decided to call it Conference on Law and Justice so that all the fields of law can be discussed here and we can come up with some solutions, new ideas, ways of better implementations, and new concerns in our legal norms. So we have included intellectual property rights, cyber laws, laws relating to women and children, justice delivery system, labor laws. I think almost all the areas of laws have been included in this theme. And as I was going through the papers that we received, I have seen that some very new problems which are faced by the nation these times are being discussed in this conference. I have seen a paper on caste-based reservations, living wills, even the concept and the dispute regarding Santhara, IPR fields. I'm happy that all new fields, all new concerns are touched by the participants in this conference. And I'm very grateful to all the participants who came up with their new ideas, new areas of concern, and their suggestions for the improvement. So I'm looking forward to a very active deliberations and participations and ideas during these 2 days of conference. And if you can come up, and it will be better if this conference will be more fruitful if at the end of the 2 days of our conference we can have some solutions for the problems that we are facing nowadays. So thank you once again to you all. Thank you very much.
Thank you, ma'am. Our chief guest for today is Honorable Justice Ravi R. Tripathi. Sir has obtained degrees of BCom, MCom in Advanced Accountancy and in Modern Business and Industry and LLM in Public International Law. He has also passed intermediate examination of Institute of Company Secretary of India. Justice Tripathi started practicing in the High Court of Gujarat on civil, criminal, constitutional, labor and specialized in service matters, and also conducted number of public interest litigation matters and attended number of lok adalats at various places in state. He had been an assistant government pleader and additional public prosecutor, during which he conducted variety of matters on behalf of government of Gujarat. During the practice, Sir had appeared for several statutory bodies like ONGC, Modasa Nagar Palika, Dhoraji Nagar Palika and Junagadh District Panchayat. Sir also got the opportunity to work as a lecturer in Manikalal Nanavati Law College and continued until elevated as the judge, High Court of Gujarat, and served till 2015. May I now invite Honorable Justice Ravi Tripathi to share his experience and knowledge with the audience.
Good morning to everybody. You did not have the breakfast properly. Right? So once again, good morning to everybody. Good morning, sir. That's right. You know, Maun has got its own benefits, but at the same time you have to be vocal where it is required, right? How many of you understand Gujarati? Well, very good number. In Gujarati they call it Na Bolwama No Gun. 9. So there are 9 merits if you don't speak. But then simultaneously they say Fakta Bole and a Bor Beche. Only those who speak, they will be able to sell their goods out. Now those goods could be your own qualities by which you can provide service. Is it right? So you will find that in every walk of life. For justice they say, justice delayed is denied. Is it? You have heard that, no? Because this is third national conference, so you must have heard. Justice delayed is denied. Then what is the other one?
Justice hurried is just.
Justice hurried is buried. So what will you do? What will you do? You will have a delayed justice or you will have the hurried justice? What will you do? Neither of the two. That's very good. But then you will have to have something, no? What will be that?
Timely justice.
Timely justice. So good. So good. Now what do you mean by timely justice? What is timely justice?
It's about considering all the aspects, keeping all the facts and things in mind, at the same time making sure that it is not taking unnecessary time, right? Because we got, since we are talking about justice, we got provisions with which things are delayed for weeks and months and years. So we can make sure that unnecessary time is not wasted.
Okay. We had Dr. Mohan Gopal. He was the director, National Judicial Academy, Bhopal. We find a very good spokesperson for judiciary in Dr. Mohan Gopal. You know, unfortunate part of this country is everybody finds it easy to blame judiciary for everything. Very easy. It's very easy to blame judiciary. Is it? Do you agree with that? You will agree after I tell you that how do they blame. In one fine morning you will find in newspaper, triple murder has taken place in some part of Surat or any part somewhere. You know, such a ghastly act, society is trembling, what not. You know, media will give its own hype. And then electronic media, they don't have anything else to do. So for 24 hours channel, that whole scene will be repeated by the end of the day at least 100 times. I don't know whether you have noticed that. You will find that very scene is repeated for 100 times. You know, sometime in that quick shot, 5 minutes में 25 खबरें, उसमें भी वो 5 बार repeat करेंगे. But then that will be done. Then a day, second day, third day, and you will find one fine morning. It depends upon the efficiency of the police. Of course, if they would have been here, they would have said, sir, we are also equally accused in the media. But then somehow or the other, at least by a week or so, in majority of the cases, the media will come out. Police is able to reach to the bottom of that particular incident. They are able to track, like that Sina murder case. Huh? There are thousands and thousands of offences are taking place. They find only one offence to be, you know, busy for the whole past all this time. I don't know. I remember one very fine joke, and that is from Haryana. Ashok Bhai will excuse me for that. After that Yuvraj, who fell into that well, no? At least thousands of fathers, they beaten their children very badly. Why? Any idea? No. Don't tell me that. Yes. Why were you walking? Open your eyes. You should have closed your eyes and you should have fallen in that well. Then I would have been on the TV in national media at least for 24 hours. Not more than that. It was, of course, it continued for a very long. Now that media will say that police is able to crack that entire story and that is done. Matter subsided. And then one fine morning again you will find a headlines. Court has granted bail to all of them. All those people, those who were trapped or tricked by the police, they are all granted bail by the court. As if the court is a culprit. As if the court is a culprit, that police people, those who worked so hard, they are able to crack that story, they are able to reach to those offenders and all that, and court has granted them bail. Now I started by saying that Dr. Mohan Gopal was a very good spokesperson for judiciary, because he said that people do not, especially the media people, they do not say that our investigating agency investigated the matter wherein 1, 2, 3, 4 and then N. I am saying N for infinite. So many weaknesses or loopholes were there. They will not never say that. Despite the fact that judge will write in his judgment that 1, 2, 3, 4, these are the points on which we find that there is no investigation at all. The blood stains are found on the cloth, but then blood group is not taken care of to find out what is the blood group. So, well, finish. Okay. By chance, if that investigation is taken care properly, there is a prosecution agency, no? You can't fight your own criminal case. If your family member is murdered, you are not allowed to appear in the court and say that, sir, I am going to do it. Of course, it is permitted sometime in Hindi movies. Is it? Salman Khan, you know, he will come forward and he will plead the case as if Ram Jethmalani is pleading that case. But anyway. And despite all these difficulties, it will be only, highlighted in the newspaper or the print media that court has granted bail to all of them. Now, in this particular situation, there is a very popular point on which, of course, Dr. Rohit Singh also referred to that. Justice is delayed in Indian courts, right? I am not defending that it is not delayed. I agree that it is delayed. But then, you must know that there is some standard by which you must measure that in this particular case that justice is delayed, and it is delayed by what measures? But what measurement it is delayed? I remember again a joke. A person went to the railway station. He said, sir, वो जम्मू जाने वाली ट्रेन आ गई? बोले नहीं, अभी नहीं आई. ओह, कब आएगी? पता नहीं. अच्छा. थोड़ी देर में एक ट्रेन आ गई. बोले सर ये ट्रेन आ गई, बोले ये तो कल वाली आई है। मतलब ये ट्रेन कल आनी थी, वो उसकी बजाय आज आई है। तो बोले फिर आप अपना टाइम टेबल क्यों रखते हैं? बोले इसलिए पता चला कि ये कल वाली है, नहीं तो पता ही नहीं चलता कल वाली है कि आज वाली है। So something is like same is with the delay of justice also. Dr. Mohan Gopal used to say that once a train starts from Delhi and it is supposed to go to Chennai, on the next station you can't say the train is late. Can you say? No. On the next station you will not be able to say that whether the train is late or not, especially when you are at Chennai, that whether train will be reaching Chennai in time or not. Meaning thereby, for every type of a case, there should be a tentative timetable, and according to the timetable, then you should judge whether this case can be said to be a delayed one or whether there is any delay in granting justice in that particular case. Say for example, there could be a very simple case which is supposed to be over by any standard, say within 3 months. If it doesn't get it over and it takes 6 months, you can say that there is 100% delay in this particular case. But there is a trial which is supposed to take 1 year, and at the 3rd month you start shouting that, oh, there is delay. That is not proper. So that is something about, the delay, and as I said, justice delayed is denied and justice hurried is buried. Fortunately for you people, Madam Shilpi has given you very two loose terms, law and justice. Now if you all are honest, I have no doubt that you are not. You are honest. If you are honest, just take a piece of paper and write down, what do you mean by law? What do you mean by law? Of course, you did refer, and it is very rightly referred even in your booklet. It says law and justice are two words that go hand in hand. Right, it is. These terms are often confusing. That's the catch. These terms are often confusing. And I'm sure that if you try to write down on a piece of paper, what do you mean by law? It will be a very tough time for you to write down what is law. And tougher will be the time when you're supposed to write down what is justice. What is justice? What is justice? If I am to compare, I'll compare justice with water. Why? Because water takes the shape of the container in which it is put. Right? So in this particular case, the water is of this shape of which the container is. Same is the case with the justice. Concept of justice varies from, if not country to country, if not from city to city, it definitely varies from system to system. It varies from system to system. And therefore one of the Supreme Court judge, he said very rightly in a program at Ahmedabad Management Association, what is justice? He said justice is when everybody gets according to his requirement. Then you can say that justice is done to all. I said, then what is left then? If everybody is to get according to the need, then what is left? Everybody is happy. Possibly even Ramraj, it was not the position. Because there also there was a washerman who was unsatisfied with the conduct of Lord Ram. And that is why he said, no, nothing doing. I am not going to behave like Lord Ram. I will not allow. He was talking to his spouse. I will not allow to be back in my home. But then the Justice of Supreme Court said further, he said that nobody gets more than what he deserves. So everybody gets according to his need or requirement, but then nobody gets more than what he deserves. Possibly a nice way of defining justice. Nice way of defining justice. And now in these days of, this computer, and when you have a mouse, and now the things are that mouse is also cordless. So you don't know that mouse is of this particular one or the other one. Everything is on your tip of fingers, You click the mouse and you get the information. And in these days, the Supreme Court has defined law and justice in number of judgments. So far as law is concerned, you will find that these are two terms which are to be, traced out somewhere in the subject which is titled as jurisprudence. How many of you know jurisprudence word? All? No. Very few. Why? What is jurisprudence?
It's a science of law.
Science of law. See, the contradiction started, you know. Science and then of law. What does it mean?
This is the technical aspect, history and all those things of how it is derived.
Okay.
So it is philosophy of law. Juris stand for the law and prudence is the philosophy. So it's basically philosophy.
I understood prudence something else. What is prudence? We do call, no? He's a very prudent man. And we like it, no? When somebody tells about us, huh? Not otherwise. If somebody tells about somebody else, no, he's very prudent, meaning that I am not. So then we don't like that also. But then anyway, jurisprudence is something where in abstract they try to understand what is law, what is justice, what are the different schools of thought, who take, trouble to find out what is law according to their own understanding. And there are number of schools. When you go higher up, you will know about that jurisprudence also. Because in first law, if we start teaching jurisprudence, I am sure that university will have tough time to get the students. The first year they come and then we start teaching them jurisprudence. There will be a very difficult time. We have to teach them, something like IPC. So he knows what is theft, what will be the punishment if the theft is committed and proved, not committed, if it is proved. In IPC, you will find all penal sections are saying if this guilt is proved, then this is the punishment, isn't it? That is how the things are settled or they are set out in the IPC. Friends, in such situation, one of the definition, if I am mistaking not, it is Austin who says, law is a command of sovereign. Law is a command of sovereign. What is law? Law is a command of sovereign. If the sovereign says, you must drive your vehicle on the right hand side of the road, you have to drive on the right hand side. You can't say, no sir, I feel more comfortable because till date I was driving on the left hand side, so allow me to drive on left. No. That is a command from the sovereign, you have to drive on right, you have no choice in that. So that is, law is the command of the sovereign. And there could be various commands, and all those commands put together, that forms the law. Law will be for a particular purpose, for a particular sphere of life. To govern that particular sphere of life, you will find set of laws for everything. If you talk little more in detail, you will find there is an act, then there are rules under that, then there are regulations under that, and then are administrative orders under that. Whole thing is taken together is a law of that particular subject. Right? So far as justice is concerned, justice you have to find out, and I am sure one thing, justice is something has very, very close relation with common sense. What did George Bernard Shaw said about common sense? What is common sense? You are talking now, last minute, you are talking something. What did George Bernard Shaw said about common sense? Nobody knows about it. He said very simple thing, common sense is not common to all. How simple it is. Common sense is not common to all. Have you heard this before? Okay, that's good. What does it mean? Common sense is not common to all. What do you mean by that? Yes. Yeah, I'm basically a teacher, so I'll be putting questions like that only, rather than addressing as a chief guest. What do you mean by that? Common sense is not common to all. What does it mean?
It means common sense is rare. It means it's rare.
It is there.
It's rare.
Rare.
It's rare. Very good. Very good. Yes. So I have basic objection about common sense. It should not have been said common sense. It should have been said super sense. And then we can understand that it is not to be found in common people. It is because it is a super sense. But anyway, we call it a common sense, and we'll have to continue to know that common sense is not common to all. Means majority of the people do not have common sense. That is our experience, and especially in Mera Bharat Mahan. We must understand that in India we are living, yes. Mera Bharat Mahan, yes. So anybody can, spit out from a running bus, and if you are driving a two-wheeler, you'll have to go back home. Because the whole shirt is having a modern art. And especially your face and everything. You'll have to go back, you'll have to wash with Dettol. Why Dettol? Why Dettol? You can have any other also. There's no difficulty. I'm not, and I mean, advertising for Dettol, so don't worry about that. I'm only saying because they advertise like that once it is washed with Dettol, the percentage of germs remains there also. But then percentage is very low or negligible. That is why Dettol I'm saying. So if that happens to you, you must remember Mera Bharat Mahan. Of course, the other says, I'm not willing to say from here, 100 में से so and so is Beiman, still Mera Bharat Mahan. That figure may vary. People say 99, but then I don't agree, because if there is a figure higher than that, I'll put that also. That is why I'm not saying. In such situation, to think about justice, you'll find that it is very common with a common sense. What could be an example of that? Two students coming to you, irrespective of their color, skin, dress color also, no difficulty, color, caste, creed, religion, they must get equal treatment. That is, if that is done, well, justice is done to them. And if on any unreasonable classification, if you put discrimination between the two, well, justice is not done to them. Justice is denied to them. And that is why, you know, I like law for simple reason. Law as a faculty, I'm saying. I like it because, in true sense, the limit for learning in law. Sky is the limit. You'll say, so what is that? What is so great about law only? Science is also equally the same thing. Sky is the limit, because every day they go on, you know, searching something, inventing something, and then they're getting Nobel Prize also for that. So sky is the limit there also. No. Law is something which is applicable to your day-to-day activities. And at every step in the life you find that, maybe sometimes wrong also, but your notion is, I am not done justice. That is a feeling normally we get. You write the same questions answer in a particular manner, the other has also written, he gets 9 and you get 7. You have a feeling of injustice. You have a feeling of injustice. Maybe it is not remedied. Maybe that there is no remedy provided for that. But then, that is why this law and justice, they are so much, you know, woven in the lifestyle itself, that it's something which is very important. And I feel that if it happens, it happens, I'll make it sure that everybody learns law. But that is also under a false hope, that at least by that they will be getting part of common sense, and they will be contributing something to the Mera Bharat Mahan concept. That is why I feel that I should make everybody learn law. But then may not be necessarily possible. Well, friends, of course you people must be having all these details with you. I have few judgments, which of course I'll be giving it to Ma'am Sharma. She'll be telling you, but then few phrases I've taken out. The word law and justice itself is defined by the Supreme Court in a case of Som Prakash Rekhi versus Union of India, reported in 1981, 1 Supreme Court cases 449. Nothing very great, huh? I have not done very detailed research on this, so don't look at me like that. There is a book which your library must be having, words and phrases in Supreme Court judgments, and you will find the long list there. And particularly when you go to the law word and the justice, you will find all these things there. Law and justice is defined, but few phrases are very important, and that is why I listed them. The next phrase is, law cannot afford to be static. Law cannot afford to be static. What does it mean? Very good. In fact, that is one of the very important topic in study of jurisprudence. When they say what is law, the law is something by which the society wants itself to be governed. The society itself wants to be governed, and for that it enacts law, of course by the mechanism available to it. If something is required to be enacted for the people in Gujarat, it has to go to the Legislative Assembly of Gujarat, and if it is wider than that, then it is supposed to go to the Parliament, and something will be enacted on that. But law is always which is enacted or which is, brought into existence with the purpose of governing that particular sphere of life of a particular person or the members of the society. And that is why they say law cannot afford to be static. You cannot have a law which will be immortal, immemorial. It will be continuing for all lifetime to come until this Prithvi goes for Mahapralay. No, there cannot be a law like that. And if it is there, it is not a law. If it is there, then it is not a law. So they say law cannot afford to be static. Next one is law has to bend before justice. Law has to bend before justice. All these things are from the judgments of the Honorable the Supreme Court. I have taken the citations, but I will be giving to her. She will be then feeling like circulating amongst you. It will be done. Law has to bend before justice. What does it mean? Somebody? Yes? Law has to bend before justice. Yes?
Law lacks, then judiciary has a power to legislate through bench. So sometimes law bends before the judiciary.
Very good. That's a very right way of putting it. Law bends before justice. And that is why we say that sources of law, when we are talking about, the first and foremost source is enactment by the particular legislative body, maybe legislative assembly, parliament, or anybody. One of the sources, law made by judges or judge-made law, as we call it, judge-made law. Why judge-made law is required? Because sometimes it may happen that court feels that no, if this particular provision of law is implemented as it is causing grave injustice, and then court can't be blind to that. And that is why they say law has to bend before justice. The same thing is said again, law is a dynamic science. Law is a living organism. Look at the words. And to that extent, I feel that English is a very powerful media of communication. Law is a dynamic science. Law is a living organism. These may be judgments by different honorable judges, and therefore different phraseology is used. Law is a living organism. Law is a phase of human life. Law is a practical instrument. Law is a warm-blooded art. Look at the expressions used. Law is a warm, not hot, mind it. The word used is warm. And whenever we talk about the human relations, we always talk about the warmth, not the heat. And that is why it says, law is a warm-blooded art. At the same time, it is said, law is not a cold-blooded craft. Same judgment, both expressions. Law is a warm-blooded art, and law is not cold-blooded craft. Very good. Law is different from morality. A little troubling point. We need not go into that much because it depends upon the situation. It depends upon the particular society wedded to something. And the best example is our Gujarat state. Prohibition is a policy which is adopted by the state, it is enforced in the state, and therefore drinking is not permitted in the state of Gujarat. In the adjoining, the moment you cross that border, it is permitted. Is it not permitted? Surat people know better because they drive their car to, what is that place? Daman. In Hindi, Daman is something different. Hindi, it is something, Daman is different. But anyway, we are not concerned with that. If you cross that border and if you do the same thing, well, no problem. And that is why they say law is different from morality. Law is different from morality. I don't know how many of you have tried to study this prohibition policy. How many of you have? Anybody? By just a general interest or knowledge? But for the love for this particular policy to our father of nation, this policy was recommended to the entire country. But then the temptation of getting that revenue, excise, it's very difficult to follow that advice. But somehow the other, the state has still continued, and let us hope that it will continue. Sometimes people do argue, so what do we get out of this prohibition policy? What do we get? In the adjoining state it is permissible, What are we going? Unnecessarily the Gujarat government is losing its revenue, which can be utilized for number of, welfare activities. That is the argument they put forward. I say do one thing. You do one thing. You are living in a state of Gujarat where prohibition policy is there. You go to the other state with your family, preferably with the grown-up children, in that also preferably grown-up daughters, and then stay there for 6 months. And then come back and tell me that whether you still say that no, there should not be prohibition policy. And the answer is always, say, sir, it is good that we are in Gujarat. And that is one of the reasons that you will find number of people here from outside Gujarat, settled in Gujarat, taken Gujarat as our home. Number of people. And if you want to make a study, you find out IAS, IPS, transferred High Court judges, all they prefer to settle in Gujarat even after retirement. This I said. Study karwa jo. Majority of them, after having completed their tenure, in normal case they are supposed to go back, to the place where they belong to. I am not making any comment on, regionalism and don't brand me as Shiv Sena, activist. I am not saying that. Don't do that. Otherwise they'll say, sir, the chief guest came and he was talking about all this. What I am saying is, it's a place which is preferred by people consciously to be here. Consciously to be here. And we were just talking with Dr. Rohit that mine is going to be the 4th generation here because my father came here. So he was the 1st generation, I was the 2nd, or I am the 2nd. My daughter is the 3rd, and daughter is blessed with a baby boy on 26th of August, so that is the 4th generation. They are going to be here only, they are not going to shift back. That is the effect of maybe one of prohibition policy. At least prohibition policy has a good contribution to make in that particular thing. Anyway, so this is law is different from morality. And as you said rightly, law must adopt new strategies to liquidate entrusted group injustice. Law must adopt new strategies to liquidate entrusted group injustices. What brought a reservation in the constitution? Have you ever come across any constitution of any country in the world which has provided something like reservation as is provided in our constitution? No. But that was required to be done because the framers of constitution, they wanted to liquidate, I'll use the same term, they wanted to do away with that group injustice. And that is why the reservation part is there. Friends, there are few things and then I'll conclude. Justice depicted to be blindfolded. That famous statue, sword and a balance and blindfolded. Well, that is the sign taken for justice.
The balance between equality and liberty.
Anybody else?
Not discriminate.
It should not discriminate, it should not be prejudiced or biased towards anyone. It should appreciate the evidence that is put before the court.
By closing your eyes, you will appreciate the evidence.
So the person will not be prejudiced or biased towards.
But he is supposed to look into sometime what is the blood group which has come on the clothes of the deceased and what was the blood group which is found in the parties. Okay. Offender is always one of the party in a criminal case. And I don't know, there is a fashion. There is a fashion and there is a passion, both. Especially to those activist groups. Rights of that offender. Rights of victim, don't talk about. They are liquidated already. The moment that man is murdered, his rights are liquidated already. Now they are more worried about the one who killed him. But then that is the scenario today. We are not commenting upon on that because some NGOs may be sitting here, they may again say that no, Chief Guest was saying something against NGOs. So tomorrow there will be headline. We don't want that also. But then there is a fashion today. Talk about the rights of inmates in jail. Sir, they are beaten by the jailer, the warden. Sometimes they are done to death. Right? I am not defending them. I am not defending. In fact, I was the one judge who made that officer to be transferred by the end of the day. The matter was at 11 o'clock. At 2:30, those two guilty officers of the jail were summoned to the court and the present DG, he was in charge of the jails at that time, IG prisons, he was also requested to be there. And by evening 5 o'clock, those 2 officers were transferred from that particular jail. That is my passion for, illegal things not to be tolerated. But fashion is there. Fashion is there. Somebody is killed, nobody is bothered. I have never come across any group who says about, no, sir, he must get his fundamental rights. He had a right to live and he is unnecessarily killed. But then if anything is done to that particular offender, the people are always there. But anyway, we are not concerned with that. Justice is depicted to be blindfolded, possibly an old notion, and it says that when you are blindfolded, it is symbolic that you are not keeping any discrimination or note of who is on this side and who is on the other side. It is only symbolic. It does not mean that the person who sits in the chair of the judge is blindfolded. He is supposed to keep his eyes wide open. Sometimes we have to apply that clip. In that one of the movie they applied clip to keep their eyes wide open. Meaning thereby you have to be mindful of every single fact which is coming before you. Next is justice fails when judges quail. Very right. Justice is bound to fail if the judge quails, because ultimately he is the instrument by which the justice is being done. And that is why it is said, I wish every one of you to give a serious thought to this, that you should join judiciary. Of course, our experience is little different. Our experience is that the students who come to this type of institutions, they always prefer to join corporate offices. Not a very happy situation, at least I am not happy with that. But then I will not be commenting again further on that, because having borrowed and all that, you have come to this institution, you are paying those fees and all that, getting your degree, then actually you have to repay all those responsibilities or liabilities. You may adopt for that, but then you must give a serious thought of joining, if not the regular practice, at least judiciary, because now judiciary is handsomely paid. After that City Commission, you can't say that judges are poorly paid. No, not at all. So you can give thought to this. Justice has no favorite except truth. Very true. And that is why our national symbol also says Satyameva Jayate. Isn't? So justice has no favorite except truth. Again, a very controversial thing. Justice is outraged when a guilty criminal gets away. And in the same judgment, it says further, justice is outraged when an innocent is punished. In both the circumstances, justice is outraged. And that is why it is the moral responsibility of the judges to put their best. Put their best means whatever ability they have in appreciating the evidence before them, they must put their best and try to find out here is a guilty person. Because in either of the case, if there is a lapse on the part of the judge, what is outrage is justice, right? The another one very nice phrase, and that is the last phrase of my list, because I think I am running over the time allotted, and that is, justice should appear to be done. What does it mean? I did not follow this. What seems? So you are making drama on the seat, that I must make a show that justice is being done. What do you mean that? Do you mean that? No. No what? Justice should appear to be done. Justice should be seen to be done. What does it mean? What exact this phrase conveys us? The first impression of this phrase is not a correct impression. The correct meaning of this phrase is that not only that you do justice, that person must be satisfied in his heart that yes, justice is being done to him. How can that be done? If I know that on one side my brother is there and the other side some other party is there, and still if I decide the case, this party is bound to have a feeling that no, he is going to decide in favor of his brother. That sort of situation should be avoided, and then it will be said that not only that justice should be done, but it must appear to that party that yes, justice is done to me. That is how you have to read this phrase. Friends, I am so happy that you all are here for your mind-storming sessions. I thank all dignitaries in absentia, and especially the organizers for having given me this opportunity to be all along with you because I love teaching. It is my passion and I got this opportunity to be here. Thank you very much. Thank you.
Thank you very much, sir, for your inspirational words.
Our guest of honor today is Dr. Vikram Desai. Dr. Desai is the principal of Siddhartha Law College, Surat, and ex-dean of Law Department, VNSGU. He has a vast experience of research and guiding the research fellows for many years. He is considered as an expert in the constitutional matters. May I now request Sir to address the august gathering.
File can you what is the meaning of law? Before he opened my file, let me start because we are running away out of time. Good morning, everybody. The chief guest of the 2 days conferences. What is the meaning of law? Yes, this. Honorable Justice Tripathi, sir. I think he is now the acting Chief Justice of the Gujarat High Court. No, sir. Sorry.
I already retired with me.
Right. Shilpi Sharma, the conference organizer and also the faculty here. Ankita Khanna, Dr. Singh. How many of you are faculty somewhere else in any university? Nice. Teachers, my dear students, friends. Justice Tripathi is a very nice speaker. I know him very well.
Thank you.
Because we met earlier on many occasions. And one more facet I would like to tell you with his permission that I have also called him as one of the external examiner for examining PhD thesis. And sir, you have gladly accepted that. Not only that, you have also came to take viva of the candidate here in our university. So that way he is taking keen interest in academic and research matters. Sir has said so many things about law and the relation of justice with the law. First of all, I must congratulate the organizers for selecting a very nice topic of discussion where Mr. Singh has thrown some good light. In fact, he has provoked me to say something about this. And I am also thankful to the organizer for calling me to deliver it as a keynote address. But when after Justice Tripathi has said so many things, I have nothing left to talk about. Still, however, I will throw some light on a very fundamental aspects of the law and justice. Because after all, if he access the justice from the point of view of the obedience and the justice delivery of the system of this court, then probably we raises doubt about it. From the point of view of the obedience to the law and also from the point of view of the delivery system, justice delivery system in this country, we always raise doubts. Justice is done or justice is not done. Law is this and law is not this like this. But what are the basic principles that governing the principle of law and justice? This is my first point that I have to tell you. I don't want to dwell in the many definitions given of law by many, from Plato to Cicero to Patton and all. I don't want to go into detail of this. But yes, the realistic definitions was given by Austin and Salmon. When Austin said, law is a sovereign command, set of rules made by the sovereign authority who has power to impose sanction, and we have to accept that definition. And Solomon says this set of rules are applied in the administration of justice. You also prescribe the rules, but incidentally you are also applied those rules in the administration of justice. Now, who is the sovereign? In democratic countries, sovereign, as what we say, the people are the sovereign. Constitution of India accepted this principle of sovereignty. We, the people of India. Start with this. So in India, it is the sovereign authority that make laws for us. Now it is only that the laws are made for the purpose of giving justice only. That is also the question. And the second thing is, what is the exact or what is the conceptual clarity of the meaning justice? Now let's say, first of all, do we say that law was not exist even before sovereign come into existence? I think, sir, we have accepted in Maneka Gandhi or many other cases that law was there even before sovereign come. Natural law, God-made law, law of karma, it was already there before sovereign made any specific legislation. What laws we are making? Governing our rules of behavior. To do this, not to do this. These are your rights, these are your duties. These are your protection. This is crime, this is inheritance, this is marriage. And we are changing also. We are making changes at the regular interval also. So when you see law made by sovereign authority who has the power to impose sanction, and we accepted that these are the rules of behavior which I have to follow. Now, sir, you have told me that 3 people has gone out from the view of that camera, they were captured, and 3 are not captured. And you raised the question, where is the justice? It is not the exact way of, I don't say another language, does not law enforce a sense of obedience in me? Whether I capture or I will not capture, that is not the issue here. Captures are going to punish. But it is that the law made only to say for capturing and then punishment. Or that law is made that I should also obey the law. I should not split. I should not talk on this mobile loudly, and I will not park my vehicle where there is no. So law provide obedience also. It is violative of that, and that if captured then invites the command or the sanction. This is the first thing. Now the second thing is this, and therefore I am going to the realistic definition. See, what Solomon said, and that is the most realistic definition of law, the body of principle recognized and applied by the state in the administration of justice. And pattern clarify that justice acts within the law. Justice doesn't go beyond the law, beyond the provision of law. And therefore Austin said that I don't only confine myself to the sovereign authority. He divided law into 3 parts. One is the state-made law, that is the sovereign law, divine law, and the human law. And human law means law made for cooperative society, for Ganesh Visarjan, for Phalana, for Navratri, for club, for hospital. These are the law we are making. Okay, we do not do this, we do not do this, we do not. There are also element of law in that, not prescribed by any sovereign authority. We are making the society में आम नहीं करूँ, society में तैम नहीं करूँ, फलाना आम करूँ. These are all the rules that we are making. So these are the 3 main facets of the law. Now, not dwelling much about on the definition of law, you also know this, but confine yourself to these basic things, that the law made by sovereign authority who has power to impose sanction. Before there is a sovereignty, there is also a principle of set of rules which we are following, and also the courts are following, and in the Solomon's way, laws are made for the administration of justice. These are the three fundamental things on which I now base my arguments. Now, what is the meaning of justice? We see justice means fairness, as what John Rawls said in the theory of justice. And the more practical, gives everyone his due to him at a given point of time. Amartya Sen is not agree with Rawal. He said justice does not confine only from the point of view of fairness. But when we look at several provisions in the law and even Indian Constitution, it is the principle of fairness that governs our the philosophy of the Constitution and also the laws. And in order to provide this fairness, we are creating institutions. And institutions created under the Constitution. And this Constitution gives you right to liberty, right to freedom of speech, right to grow, right to live, and right to die also. You have been given by the institution created under the Constitution in order to fulfill, in order to see that there is a fairness in giving this. You may have a constitution where fairness is not there. In many constitutions of the world you can see the principle of fairness is very much absent. Because this is not fair, this is not fair, this is not fair, this is unfair. Unfair treatment is meted out to me. Unfairly I have been rejected, unfairly I have been convicted, unfairly my bail has not been given. So fairness is the underlying principle in administration and delivery of the justice. And fairness is an important character of justice. Sen, Amartya Sen, I'm not, because on this basis now I will prove later on our decision that has been rendered in 67 years by our appellate judges. I will prove that the element of fairness and how it is practical and how it is acceptable. Sen, I don't accept Sen, because Sen has doubt on institution also. He said institution is created by whom? And if the bad institution is created, there is no guarantee of justice. That may be another story, and that was he said about it, because both are economists, and therefore they are talking in terms of economic justice also, with which we are not concerned with here. But when we talk about elements of fairness, we are creating an institutions. We have a written constitution, and Article 13 said all laws inconsistent with these provisions, not only fundamental right, all these things which are there, economic laws, family laws, taxation laws, land laws, they are subjected to the constitutional legislation or constitutional philosophy of fairness. Land Acquisition Act. My land has been taken away, compensation is given to me. Not only compensation, due compensation is given to me, reasonable compensation. Won't you find element of fairness here? And that is Constitution state. Liberty, my liberty has taken away. Religion, freedom of religion. Believe in God, not to believe in God. Nobody compelled me to say Bhagwan Astitva mach, and nobody compelled me to say Bhagwan ma tame mano se dekho tu. So, friends, what John Rawls said, fairness transcendental approaches is based on tradition. Then having chosen consumption of justice, we can suppose that they due to choose a constitution and a legislature to enact a law. These norms set out and we have to agree to it. In all legislation that we are making, we have in mind this element of fairness. And whatever legislations we are made, and see what is the latest case in examining this element of fairness. Mammon case. Mammon, he hanged, but at midnight the judges assembled and they try to examine whether there is injustice, whether we have forgotten something. Therefore, in proof that nothing wrong has been done, in a fair justice has been given to him, we are opening the court at midnight. So nobody will cast a doubt that you have unfairly treated this person. This is the gist of what the justice is. And we have to understand the justice in this meaning. Now let us examine this. If you understand the meaning of law and justice in this way, now see, why we accept natural law as a guiding force when we are dealing with any legislation. Where is natural law? Is there any act? Natural law act. Have you come across that act? No. But in every judgment, three parties have said just the rules of natural law, justice is violated. Where is that natural justice violated? Where are they? Where are they? And then we are saying, no, sir. Natural law and natural justice demands element of fairness. Which element of fairness? Two principles. Notice, actually three principles, but in jurisprudence we are talking about two principles. No one should be judged in his own cause, and the second is ad alteram patent. Sufficient opportunity of hearing, not only opportunity of hearing, but sufficient opportunity of hearing must be given to the person before passing any order. There are three elements: notice, opportunity of hearing, impartial tribunal. These are the three main principles of natural justice. So when any matters go to court, first thing we examine is this, put aside this law and everything, evidence and everything. Have you given the notice? Have you given him opportunity of hearing? The matter I am deciding here, whether I have any interest in this case, first you have to examine these three things. Without keeping in the merits of the case, we will decide merit afterwards. Let me first clarify these three things. Whether some notice has been given to the parties, whether sufficient opportunity has been given to him for hearing, and the third one is whether I have any personal interest in this matter. So I will go out. Unless these three basic principles are not satisfied, I will not proceed with the matter as a judge. I will not proceed as a collector, as a tribunal. And this is what our lamented ex-Chief Justice Bhagwati said in Menka Gandhi. Menka Gandhi could never have been decided on the practical interpretation of Passport Act. No, sir. This is my firm view. An academician, I also do not agree with the observation made in Menka Gandhi case. That was the another story, because you cannot go against the will of the Constitutional Assembly debates. But I don't want to discuss this. That is not the time here and the subject here. Sir, what is natural justice? Because if you cannot invoke this rule of natural justice, Menka Gandhi could not have been decided in this way. It could have been decided the way in which Gopalan was decided. There is a law, there is a procedure, everything is over. There is a law, Passport Act, and therein you have violated. Your passport was important because you are faced inquiry before the SAR Commission. You are not allowed to go. Finish. But no. Bhagwati has some other route he has taken while deciding the matter. And that what he wrote in his judgment. Natural justice, hear carefully, all of you sitting here. If you want to clearly understand the relation between law and justice, what is the meaning of law and then what is the meaning of justice and what is the correlation between law and justice, hear carefully. Natural justice is a great humanizing principle intent to invest law with fairness and to secure justice, and over the years it has grown into a widely pervasive rule affecting large areas of administrative action. The inquiry must always be does fairness in action demand that an opportunity to be heard should be given to person affected by the order or not. Be it is a judicial function, be it is an administrative function, or whatever it may be. You have to examine these three things. If you have not examined these three things, or if you are violating these three things, then you are not doing justice to anybody. Maybe you are jurisprudentially correct, maybe your evaluation of evidence is correct, you have not given justice if these three principles or any of one of is violating. And therefore, the soul of natural justice is fairness, right, Bhagavati, in Menka. Its aim is to secure justice or to put negativing to prevent miscarriage of justice. This is a very bold statement. Its aim is to secure justice or to put negatively to prevent miscarriage of justice. Therefore, at one point of time, there was a debate. International Jurist Conference was held in New Delhi. Honorable Justice D.A. Desai, the late Justice D.A. Desai, put two questions. What is the correlation between law and justice? Whether the Indian courts are court of law or court of justice. And then he said, maybe for the purpose of discussion, he said, justice according to law is a myth. That was the statement he made. I don't see that justice is made according to law. That is what you have also said. Because after all, legal justice bases on the evidence and interpretation of the evidence and evaluation of the evidence. Maybe by there you are doing injustice also. People who loses in the court say, what type of it? Therefore, Justice Ehlrich said of the American, there is no guarantee of justice except according to the personality of a judge. Who is delivering the justice? It depends upon the quality of the judges that is giving justice. And therefore, now in this background I am giving you 2-3 examples. Justice Desai said, I don't agree that justice is according to law. Because justice according to law is made, still the social philosophy of a judge doesn't intervene in it. While doing justice, a judge has to keep in mind all these factors, fairness and reasonable opportunity and this is. He has to put aside his prejudices, his beliefs, his notions of taking the things. He must be an impartial person. But the great Benjamin Cardozo said, it is not possible. In the nature of judicial process, he said, every judge, even a learned and conscientious judge, has his philosophy of his own. And by when the case is even balanced, you can go this way or you can go this way, that intervening factors came into play and the judge will go this way. So one judge say, I belongs to labor, the other judge say, I belongs to property, one say, I belongs to liberty, the other say, I am not belong to liberty. This way it will go. Therefore he said, a justice can deliver a real judgment when it looks that he remains totally impartial in delivering this justice. साहब कहते 24/7 न्यूज़ आवे, but either while rejecting a bail application, if he has that notion fixed in mind, he is not delivering justice. He should keep aside of all these things. કે ટીવીમાં કાલે બધું બહુ આવ્યું ને મારું પેપરમાં નામ આવશે ને તેને કારણે હું સેલિબ્રિટી રોલ થઈ જઈશ. That was not the point. That was not the things that he has to decide by administrating justice. And therefore DNS I said, I must imbibe constitutional philosophy of justice when I am doing justice. I may belong to property class, But when it comes to make a justice, I must say, Indian Constitution talk about socialism. Indian Constitution talk about the philosophy of fairness, of impartial justice. So, while dealing labor matters, while dealing matters relating to liberty, while dealing with matrimonial matters, I have to remain within the four corners of what is there in Indian Constitution and the several provisions prescribed there in the Indian Constitution. Even economic justice. See, what is the difference between that fellow John Rowell and Amartya Sen? John Rowell said, your all economic benefits must be so distributed that serves of the common good. Is it not there in the directive principle of state policy? Is it there in the directive principle of state policy? But when a judge said, no, in globalization, somebody was talking about globalization, and what would the meaning, what is the importance of justice in globalization era? Yes, there was a problem of economic justice in globalization, because constitutionally said what? There must be a balance, right to equality between have and have-nots. And the promised millennium is, you want to assure is, establish egalitarian society. Equality must be available to all. Equality of opportunity, equality of office. And the economic policies are not to be decided which concentrate the capitalism, which create capitalism. This is not there in the Constitution. Constitution says about social justice. And in globalization, all our economic laws are now we are remolding, which to my understanding, also creating some sort of capitalism. Natural resources are not distributed for common good. We have 2G cases, and these coal cases are with us, where the later on Supreme Court intervened and cancelled all these auctions. So friends, these two terms are very, very lengthy terms, very wide terms. It would take hours to get it understood. But when I am preparing my homework for this lecture, and this is what I take from the lecture of Justice D.A. Desai, is not fair element of law and justice, philosophy of fair element law and justice is imbibed in the Indian Constitution itself. And if any judge dare to say that I will go out of this Constitution and decide the matter in my own way, I will not follow Maneka Gandhi, or I will not follow Gopalan, or I will not follow Keswanand Bharti, or I will not follow the other cases, TMA Pai, then I think he is not doing justice. Now this is the last part of my lecture. In 67 years, Pradipati said, in my evaluation, there was no proper evaluation has been made after what Professor Godboys has made about the working of the Indian Supreme Court. But then when I read Granville Austin, the working of the Indian Constitution in the last 50 years, and the latest book of Abhinav Chandrachud, how the Supreme Court and High Court has worked, I say, and I believe also what I say, and this is not only to praise you, sir, but he says that look at so many judgments on all the branches of law, say labor law or taxation or family or liberty or IPC. We strictly remain with this philosophy. We have not deviated it. Yes, there are only 2-3 incidents during the time of emergency where we have deviated in Sukang, except that in all the cases delivered by the Supreme Court, not only by the Supreme Court and High Court. I don't want to undermine the judgment, the justice given by the Mufsil courts also. I don't speak lower courts because Upendra Bakshi says you cannot say one court is lower and one court is upper. They are all similar courts and they are the similar way of doing the justice. But when you go to the lower courts also, or the lower judiciary also, they are imparting a good justice. That was my personal evaluation. I am not talking just after hearing so many things, because I have seen this closely. that very fair opportunities are given for production of document, for submitting the evidence, and all these things. Delay must be there, sir. We cannot go hurriedly by giving judgment. That is a very bad element. Yes, not too much delay. Delay to the extent it is tolerated. Not too much delay that the value of judgment is over. Because in one of the cases, a very interesting case in the Supreme Court, a person was dismissed by the from his employer. The court went to labor court, industrial court, high court, and then to Supreme Court. 40 years by the time he died. And the court found that the dismissal order was wrong. It was an arbitrary order passed by the employer. So judge said, now what we can do? There is no case of reinstatement now. And here comes the philosophy of a judge, and that is called justice, sir. No, now we want to do justice. No matter he right. Now calculate all his salaries from day one. From day one. It goes to 2,50,000. That this judgment was delivered in 1978. 2,50,000. And somebody, what you talking about? Justice seems to be done. And what is this justice seems to be done? I will show you here. And the judge said, 2,50,000 to be given within 30 days. Within 30 days. And I direct income tax authority not to calculate this is the income of this year. But it is to be distributed from that day one, so that he shall not have to pay any amount of income tax on this 2,50,000. This is what justice seems to have been done. Otherwise, they could have deducted the income tax from that amount and then said, let's cover this 1,50,000. This is justice, and this is justice seems to be done. This is the element fairness. Friends, I have taken much of your time. I think there are you as a young persons. Now we are in the afternoon of our retirement at Bakshi age. Very 2-3 years left in it. But the major problem which I have seen is, this is a line of advice to all of the students and teachers also. When you read the law, you must first examine how this law was enacted and what is the background of this law, what is the philosophy of enacting this law, why this law. Every provision has a jurisprudence basis. One day in district court, a question was put by me to an honorable district and session judge, why section 125 was enacted in criminal procedure code. It is civil liability to pay maintenance to the wife, deserted wife. But why it is a criminal? What crime I have committed? What is the jurisprudential basis of enacting this provision in the criminal law? So we fasten the proceeding so that ultimately hurried justice can be given. Because if it is civil liability, then you say, oh, no, okay. No. Now you see from where 125 comes. 125 comes from our scriptures. The source is scriptures. And therefore the husband bound to maintain. This is only the procedure. This is not the right that I have come here you. But here I come here to implement my right. And therefore the district judge said, out of 100 cases, I cannot reject any maintenance application. I have to give it. One day one person said, she is MSc PhD. Why you are giving her maintenance? She can earn more money. No, don't. Law doesn't permit me this. Law said you have to maintain her. Law said you have to maintain. And our Gujarat High Court in Muni Kunti Vijayji's case, a very interesting case of 125, a person married 2-3 children, he became sadhu. Wife filed maintenance application. They say, I have renounced the world. Everyone is my sister. My wife is also my sister. She is not my wife. I am not bound to maintain her. It just says sit down first. Don't talk nonsense. Law doesn't permit you, because children are all your children. And you have converted, that doesn't cease to be your responsibility to maintain your wife. If we do justice in this way, then many will convert it too. So, thank you all of you. I think you must have been given some thought for deliberation for today's conferences. But try to read every provision of law, from where it has come, what is the base of that provision. Because one day Justice D.A. Desai told me, sir, I have done PhD on him in his philosophy. I have examined his 175 judgments. And each of every judgment I have discussed with him, why this and why this does. So he said, there was one provision in Hindu marriage law, that a divorce take place after 1 year, you cannot remarry. Now somebody has challenged it. Why now you are preventing me? I have already taken divorce. Now I must be allowed to marry. Now here comes the case of reasonableness and fairness. Why 1 year? Supreme Court has to examine this. Why this is gap of 1 year? Why not 2 months, 3 months, 6 months, 7 months, 8? And so DLSA said, we just examining the marriage and divorce law of the world. And we come across the provision of Muslim divorce law, where the 6 months period was fixed, limitation was fixed, not to remarry. Why? If she has conceived by that husband, by the time the result has come, but not more than 6 months. Therefore, we have struck down that provision. This is an unreasonable restriction that has been put for remarrying after taking divorce. So, what the point I would like to making is, there must be some reason, some sort of justification to prove that this. We have seen, also now, 309 Supreme Court has struck down that suicide is not an offense. If a person committing suicide and if he, see, fortunately if he die, see, again prosecution में एक तो दुखी माना है वधारे दुखी करो भाषा. He want to end his life for his sorrows, and now you are adding the sorrows. Supreme Court said this is not good. This is not good. Don't punish him now. Do this something so that he can live again peacefully. 309 in this way is ultra virus to 21. That is right to live. So thank you very much, sir. I think we have taken much of your time, sir. And I also thanks again for calling me here. Thank you.
Thank you, sir, for sharing your knowledge with us. It's my privilege to introduce Dr. Ankita Khanna to you. Dr. Khanna is a faculty in School of Management at Oro University and also the coordinator of this conference. May I now invite Dr. Ankita Khanna to kindly present the closing remarks. Honorable Justice Ravi Tripathi, Dr. Vikram Desai, Dr. Rohit Singh, Professor Shilpi Sharma, our most valued invited guests, participants, and my dear friends. It's my privilege to deliver closing remarks on this occasion. First of all, on behalf of Oro University, I am honored to welcome you all to the 3rd National Conference on Law and Justice 2015. The world of law and justice is an exciting area to work in, and we intend to meet every year and bring inspired people together in forums like this to ensure that the School of Law remains at the cutting edge. I, on behalf of Oro University, extend a heartiest welcome to one and all present here. I mention our deep sense of appreciation for Justice Ravi Tripathi for his valuable contribution to this conference. On this occasion, I would like to express our gratitude towards him by presenting him a memento. May I now request Professor Shilpi Sharma to kindly present a memento to Justice Ravi Tripathi. I also express my heartfelt thanks to Dr. Vikram Desai for sparing his valuable time for us and also for the support and guidance he has extended to all of us. May I now request Dr. Rohit Singh to kindly present the memento to Dr. Vikram Desai. Before I close, I would like to thank each one of you for sparing your valuable time for attending this conference and bringing your expertise to our gathering. You, as organizational leaders, educators, and students of law, have the vision, knowledge, and experience to help us pave our way into the future. I take this opportunity to welcome all the participants and delegates in this conference and request them to engage in fruitful deliberations. I am already, feeling charged while listening to these two speakers, and I really look forward to great, interesting discussions and deliberations during the sessions. So I really wish all of you all the best for your coming sessions and presentations, and have a wonderful stay here. And thank you so much for being here. Thank you.